Good day, everyone. So, before we start our discussion, let us bow our head and feel the presence of our Lord.
Dear Lord, thank you for giving us another wonderful day. We hope that this day will be full of learning. We ask for your guidance as we go through our lessons this day. Help us open our heart and mind and inspire us to do good, not only in our studies but in our attitude as well. Bless our teacher and give them sharp mind as they instill their knowledge unto us. We know that this day will be fruitful as long as you guide us in everything we do. We thank you, our Lord, in the name of Jesus. Amen.
Hello, everyone. I am Tulipan Kimberly from BSC 33, and I am here to discuss the alternative dispute resolution of Philippines and Australia. Let's identify their differences and similarities when it comes to ADR. But before we proceed to the two countries, let's define first what is ADR. Alternative Dispute Resolution or ADR refers to the different ways people can resolve disputes without a trial. Common ADR processes include mediation, arbitration, and neutral evaluation. So, for example, in arbitration agreement between employers and employees. So, to resolve disputes, they use arbitration agreement or arbitration process rather than a lawsuit because it is more flexible and less expensive. So let's proceed to the ADR of Philippines. So in the Philippines, alternative dispute resolution refers to the process of resolving disputes outside of the traditional court system. It involves the use of various methods such as arbitration, mediation, and negotiations to settle conflicts in a more efficient and cost-effective manner. Next, ADR Act of 2004, also known as Republic Act number 9285, is a significant piece of legislation in the Philippines. Why? Because it institutionalized the use of ADR systems in the country. This act established the framework for the use of ADR mechanisms as alternatives to traditional court litigation. So, next, under this law, the state shall encourage and actively promote the use of ADR as an important means to achieve expediency and impartial justice and backlog court dockets. So, in short, Philippines use ADR to reduce the congestion in the court system and also to improve the overall administration of justice. So, let's proceed to the people behind the ADR of Philippines. So, first is Alfredo Flores Tachar. He was a Filipino attorney whose strong advocacy for and commitment to the alternative dispute resolution movement has led to his recognition by Chief Justice Hilario Davide Jr. as the father of ADR in the Philippines. Take note of that class. He is the father of ADR in the Philippines. Next is Attorney Christine B. Pangilinan Canlafan is the supervising director of the Alternate Dispute Resolution Services of the IPO-PHL-BLA. She is also the designated focal person for ADR both for the Department of Justice, Office for Alternate Dispute Resolution, and the World Intellectual Property Organization. Attorney Canlapan saw the benefits of ADR in solving any kind of conflict, including IP disputes. She passionately advocates the paradigm shift from IP litigation to IP dispute resolution. Take note of that class. So let's proceed with the purpose of ADR in the Philippines. So first is to raise awareness of the benefits of arbitration and other forms of alternative dispute resolution throughout the Philippines. Next is to reduce the backlog of cases in the courts. So, like I said before, Philippines use ADR to reduce the congestion in the court system. Next is to ensure a speedy settlement of disputes, and lastly, to provide an efficient tool for solving appropriate cases outside of the court system. Let's proceed to the EDR of Australia. So, the Australian government has established the National Alternative Dispute Resolution Advisory Council or NADRAC, who play an important role in Australia by providing policy advice to the Attorney General of Australia on alternative dispute resolution matters. Many Australian courts offer court annex mediation services, which provide parties with an opportunity to resolve disputes through mediation before proceeding to trial. The Australian government encouraged each agencies to use ADR to resolve disputes, and many agencies have established internal ADR processes to resolve disputes with the public and other stakeholders. So, the government of Australia provided funding for ADR development projects. Class, they also established the Australian International Dispute Center, which provides ADR services for international disputes. So let's proceed to the important milestones of ADR in Australia. So first is, in 1970s, the first community mediation centers were established in Australia in the 1970s, providing an alternative to litigation for solving disputes. Next is, in 1980s, the Australian government established the Australian Institute of Judicial Administration, which provided training and education programs for judges and lawyers on ADR. Next is, in 2003, the government established the Federal Magistrates Court, which had a strong focus on ADR. Next is, in 2009, the government released a report, The Resolve to Resolve Embracing ADR to Improve Access to Justice and a Federal Jurisdiction, which emphasized the importance of ADR in improving access to justice. And lastly, in 2011, the Civil Dispute Resolution Act 2011 was enacted, which encouraged parties to take genuine steps to resolve disputes before commencing litigation. So let's proceed to the people behind the ADR of Australia. So first is Professor Tanya Sourdin, a leading academic and researcher in ADR. Professor Sourdin has made significant contributions to the development of ADR policy and practice in Australia. So class, take note of that. Next is Hon Justin Kevin Bell, a former Supreme Court judge. Justice Bell has been a prominent figure in ADR, serving as the chairperson of the National Alternative Dispute Resolution Advisory Council, NADRAC. Last is Dr. Lola Akin Ojelabi, a renowned ADR practitioner and educator. Dr. Ojelabi has worked tirelessly to promote ADR in Australia and has developed innovative ADR programs. Let's proceed to the purpose of ADR in Australia. So first is to reduce the congestion in Australian courts and elevate the burden on the judicial systems, like on the ADR of Philippines. Next is to provide a fair, efficient, and cost-effective means of resolving disputes. And lastly, to offer flexible procedures that can be tailored to the needs of the parties involved, unlike the rigid structure of court processes. So, as you notice, same lang silang purpose ng ADR of Philippines. So, let's proceed to their similarities and differences. So, their similarity, both countries recognize the importance of ADR as a viable alternative to litigation. In both countries, ADR is seen as a means to increase access to justice for populations that cannot or will not use the court system. And their difference, the Philippines has a more established framework for ADR with specialized rules and proceedings for intra-corporate disputes. In contrast, Australia has been promoting ADR as the normal way to resolve disputes with a focus on adopting common definitions about legal services. Um, Additionally to their difference, class, ADR of the Philippines is more active, take note of that class, compared to Australia due to its strong legislative framework and government support. Our government launched initiatives to increase awareness and promote the use of ADR among individuals. So, this is the end of our discussion class. I hope that you learned a lot from me. Thank you for listening. Future Public Serve.